Welcome back to Closing Arguments. I'm Julie Grant, sitting in this week for Vinnie Politan. We kick off this hour of the program with the University of Idaho student murders case. Last November, these beautiful young people, Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin, were found brutally stabbed to death in their off-campus home. Bryan Kohberger is the accused in this case, facing 4 charges of first-degree murder and charges of burglary as well. Now, earlier this week, his defense attorney filed some more documents and says that she's planning on arguing 2 different motions during an upcoming hearing set for this Friday. Before we get into that, let's recap together what we know so far about Bryan Kohberger.
You read the affidavit and you just find out that nobody understands exactly why, but he was stalking them, he was hunting them.
The maximum penalty for that offense, if you plead guilty or are found guilty, is up to death and/or imprisonment for life. Do you understand?
Yes.
This was probably a person that blends into the background.
Yeah, where I'm from Pennsylvania, we actually don't have like crosswalks.
His neighbors and people who know him superficially would probably never guess that he had any violent tendencies.
It's disgusting to think about someone that you used to hang out with all the time could do something like this.
Are you waiving your right to a speedy preliminary hearing?
Yes.
If you got to know him well, you would see layers of things that were a bit off or different.
What I do know is that Bryan did have anger issues.
You could tell there was some off about him. Very quiet, calculated about what he says. Actually very similar to how he walked into court, no different.
I'm just curious about the law. I don't mean to...
Oh, no, yeah, I can find it for you. Yeah.
Everything that I've read about Bryan Kohberger would fit the type of person that we would expect for doing a crime like this.
The 2 motions that Kohberger's attorney plans to argue this Friday are a motion to compel and a motion to stay the proceedings. The motion to compel was originally filed on May 3rd, and here are a few of the things that they're requesting. They're wanting a copy of all communications between laboratory personnel and any other party with regard to biological testing in this case, including letters, memos, emails, texts, and records of telephone conversations. They're wanting all documents related to any genetic genealogy search, including but not limited to the creation of user profiles, accounts information, automated search results, uploading of data, all queries and search results from any private or public data banks, all documents relating to the comparison of any DNA samples collected during the genealogy investigation of the crime scene evidence. Now, as for the motion to stay the proceedings, originally filed on July 25th, the defense is asking the court to postpone the trial, citing a possible error in the grand jury process. One of the main motivations behind the defense's aggressive pretrial litigation might be, just might be, the state's announcement that they're seeking the death penalty for Bryan Kohberger. And a new Idaho law allows the possibility of death by firing squad as well. Court TV anchor Michael Ayala has more for us tonight.
Murder in the first degree, maximum penalties, life in prison, or the death penalty.
Bryan Kohberger could get the death penalty if he's convicted of first-degree murder in the stabbing deaths of 4 University of Idaho students.
Do you understand the maximum penalty? Yes.
The new law in Idaho could mean execution by firing squad if Kohberger is found guilty and sentenced to death.
We need to bring back the firing squad.
State Representative Bruce Skog co-sponsored the bill to make the firing squad a secondary method of execution in Idaho.
We have 8 people on death row now, but we've been unable to carry out some of those death sentences because we cannot get the pentobarbital for various reasons. So this firing squad is the backup method if we can't get the pentobarbital.
In recent years, pharmaceutical companies have filed lawsuits to prevent their drugs from being used in lethal injections. It's making it more difficult for states to carry out executions by lethal injection.
Pentobarbital does not have a long shelf life, so it's not as if we can stock up and hold on to it for years.
Idaho called off its scheduled execution of Gerald Pizzuto Jr. in December of 2022 after it couldn't obtain the necessary chemicals to put him to death. Pizzuto has been on death row for nearly 40 years after being convicted of murder in the deaths of an Idaho couple.
None of the firing squad executions, approximately 150 or so in recent recorded history, have been watched.
David Leroy is Idaho's former attorney general, now a defense attorney.
I think a good argument can be made that it's a humane method of execution. There is a cruelty factor, I think, of lingering between, as we have here in Idaho, 40 years and 7 years on death row, unknowing whether that sentence will be ultimately executed.
Skog says they look to Utah for direction. It's where the last firing squad execution took place.
There may be a panel of 5 or 6 persons with rifles, and one of them has a blank in it so that they're not sure who had the blank.
There is no method of execution that will always work perfectly.
Robin Marr is the executive director of the Death Penalty Information Center, which studies the death penalty.
As long as we have human beings involved in that protocol, there are going to be opportunities for mistakes. And certainly there may be problems with the firing squad.
That was Michael Ayala reporting for us tonight. Let's bring in the think tank, shall we? We got a great tank on the program tonight. In Seattle, Washington, trial attorney, author of Justice in the Age of Judgment, and fellow of the American College of Trial Lawyers, Ann Bremner. Also with us tonight in Los Angeles, deputy public defender for the LA County, Philip Dubé. And in Atlanta, Georgia, criminal defense attorney, former federal prosecutor, and professor of law at Texas Southern University, Michael Sterling. Welcome to you all. It's so nice to see you tonight. Boy, oh boy, there's a lot to talk about here with Bryan Kohberger, especially this motion to compel. Essentially, what the defense team is doing here is trying to get the court to order the state to turn over so much information about the DNA testing, any other profiles that might have been uploaded to a database, everything uncovered in the genealogy testing and the searching, any communications, even between the people at the lab. I mean, I was reading this motion, like thinking to myself, my goodness. And the state is saying in their responsive motion they filed to the first one, look, we don't have to turn all of this stuff over to them per Idaho law. So I'm curious what the judge is going to do on Friday. Let's unpack this. Let's look at this from the defense perspective, because they're the one moving here, trying to get this turned over. Let me go to my defense attorneys to kick things off. Michael Sterling, let me start with you, please. Is this defense team being unreasonable, asking for all of this information in that motion to compel? Why or why not, please?
Yeah, I don't think so. I mean, if you're the defense team, you got to ask for everything you can get, right? So, and usually what happens when you see a motion like this, they're probably relying on an expert to say, what is it that you need to give me a full analysis of everything that could lead you to a conclusion, give you an expert opinion. So it's very likely that the defense team is relying on some expert to say, what is it, what type of information do you need that could give us some alternative analysis based on what's available. And so I don't think they're being unreasonable. You have to ask for everything, and then you hope maybe the judge gives you a few of the things you ask for, enough for your expert to provide the analysis. But I don't think they're being unreasonable, Julie.
Sure. I hear you, Michael. You know, I had a defense attorney friend of mine say to me one time when I was a prosecutor and we were trying to work out a deal, I was like, I can't believe you're asking me for that. He's like, Julie, you have to always ask for more than you think you deserve, right, when you're a defense attorney. I'm like, hey, I can't blame you. I really can't. Philip Dubé, I see you smiling there. What do you think? The defense team, are they right on in this very detailed request?
Oh, yes. You know, recognize that defense attorneys have legal duties. You know, unlike prosecutors who only have to bring charges based on probable cause and in good faith, you know, we represent individuals. And in this particular case, the young man is looking at death. But I find one of the most important pieces of discovery that they want is what's called that candidate list. Okay? And what that means is other hits, other profiles that came up when they uploaded Mr. Kohberger's DNA profile into CODIS or the state and local data banks, where they got hits that either were close to Bryan Kohberger's DNA profile or maybe a little bit further away than a match. And the expert for the defense might want to see what other candidates in the DNA data bank closely matched Bryan? Because if there is somebody else, they can put on a third-party culpability defense that some other dude did it type defense. And remember, they don't have access to it. They have to go through the courts to get it. If they cannot get it informally from a prosecutor, they have to bring a motion to compel production of the discovery. It's required by law, and frankly, it's malpractice not to seek it.
Appreciate it, Philip. Thank you for that. I want to get to this motion to stay the proceedings, meaning let's just bring everything to a screeching halt. And the basis, they're being somewhat specific, somewhat vague, too. They're saying it all has to do with the grand jury. We know that is how we got the case from little court up to big court. They did it by secret grand jury, which they can do in Idaho, or they can have a preliminary hearing. And Kohberger thought he was having the preliminary hearing. We had the date set, remember, from January to June. I was like screaming about it, going, why this long for just the prelim? And here the prosecutors did their roundabout and just sent it up to the bigger court that way. And the defense team is saying here, Ann Bremner, that they've reviewed the records of the grand jury convening, the process that went on, and they said there's an apparent failure that occurred and further investigation is warranted, but they're not saying what the failure was exactly. Ann, what do you think? Do you think, is this a stall tactic by the defense? Is this a way to buy them more time, frustrate the prosecution? What do you make of it, please?
Probably all the above. If you look at, and I mean, you look at all this and you think, look at Lori Daybell. Remember, they struck the death penalty for discovery violations in that case. I mean, maybe they're hoping for the same thing here. But the other part of it is that, yeah, they're pretty vague about it, but they've been pretty vague in a lot of their motions. Remember, on exculpatory evidence, what was that? You know, that there was a motion regarding reported exculpatory evidence. So I'm not really sure what they're getting at. Was it representative at the jury panel for the grand jury? Were there qualifying questionnaires that were somehow deficient? You know, well, they need to investigate, but they've kind of raised a specter of what those kinds of concerns could be so they can get that stay. But, you know, this is a no-holds-barred defense. I mean, you have to say it's impressive. They're busy defending their client.
Well said, Ann. You know, with what they're doing right now, I always say on this show, never get mad at the defense attorneys. It is a tough job to do. It can be a very thankless job, and their job is to advocate for him. And so that being said, they are being very detailed, very thorough, really giving him the best defense under the law, which he is entitled to, you know, per the Idaho Constitution and our U.S. Constitution, as you all know. And in terms of what we may see here, I don't see them really letting up. I was starting to think, you know, could we perhaps maybe see a plea? Are we really going to see this case go the distance? And I'm wondering, you know, Michael Sterling, I know we don't have a crystal ball, but based on the motions that you've reviewed, the analysis you've given, you've been following this from the inception, you all have. But Michael, to you on this before we have to hit a break, do you think we're going to see this case go to trial?
Probably. Probably. I mean, the only thing there to plead out is taking death penalty off the table, right? So, right. I mean, you know, for murder cases, typically what you see is if prosecutors aren't willing, usually death isn't on the table, but when it is, the only thing to plead is if you take the death penalty off the table and my client can get life, you know, without the possibility of parole, where he's not provided, there's no death penalty on the table. That's the entire sort of negotiating tool. And so outside of that, if death is still on the table, life in prison without the possibility of parole is still on the table. Unless they take death off the table, you're not likely going to see a plea negotiation.